There's a very specific order of how hearings and trials happen. Usually it goes like this. When you first show up in court, make sure you're on time. After you enter the courtroom, you can go up to the in-court clerk, who will be seated to my right, and identify yourself. The court clerk is probably preparing the courtroom at the time that you come into the court. Tell the in-court clerk your name, and he or she will direct you at which table to sit down. The tables are to my left. After both parties are present, the in-court will tell the judge the parties are ready. Then the in-court clerk will leave the room and go get the judge and come in through the door that is behind me. The judge will enter and tell everyone to be seated.
My name is Spencer Jackson. I have a hearing scheduled this morning.
You can have a seat at the table.
Okay, thank you.
Are both parties ready to proceed?
Yes.
Yes, I'm ready.
Okay, I'll get the judge. All rise. Court is now in session with the Honorable Judge Peterson.
Good morning. You may be seated. I'd like to call the case of Spencer Jackson versus Antoinette Jackson. The case number is 3AN 55556. The case will proceed as follows. I'll give both parties the opportunity to present their evidence. I'd like to have each party present an opening statement, brief in nature, telling the court what they intend to prove and why they intend to prove the issue that is to be decided. After that opening statement, we'll proceed with the evidence. The plaintiff will go first. The plaintiff will have the ability to testify and testify thoroughly, and call witnesses if necessary, and present written evidence if desired. As the plaintiff testifies and any witness, the defense will have the opportunity to re-examine, examine, and question the individual about the testimony that's given here in open court. After the plaintiff is done, then the like courtesy will be given to the defense, and the defendant may testify, call witnesses, or present written evidence, and likewise the plaintiff will have the opportunity to ask questions of the defense witnesses and the defendant as to the testimony given here in open court. After all the evidence is admitted, I will allow closing arguments by both parties, which will essentially be an opportunity for each party to argue what was presented, how it should be viewed, and what the importance of each of those issues and the pieces of evidence might be, and how the court should view the same. After that is done, a decision will be made, and a decision will be placed in writing for both parties to have, which probably will come in the mail after we have the hearing today. I would caution both of you to please do not interrupt each other as the other is testifying. You will be given the opportunity to ask questions, and you will be given the opportunity to testify yourself. Are the parties ready to proceed, and are there any questions?